Yeah, how do we eradicate bad HOAs? I mean, at the end of the day,
that's the mission.
It's empowerment, it's reform, it's education, it's advocacy, it's all of these things.
Yeah.
And the goal is to eradicate.
Yeah.
Big goals. I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Ellis Carlson Law and host of Bad HOA. Welcome back. Today, as usual, I have Marty. Marty, welcome.
Hi there. Good afternoon, or good morning, good afternoon, good evening. What was the Truman Show line?
I think you were in the
good
space
afternoon,
of it.
good evening, and good night. In
go.
case I don't see. Okay, that's what it was. Okay.
Welcome, and we have an exciting topic today, which I love. Do you want me to jump right into it, or do you want to? What are your thoughts on this one?
No, this one is exciting because I think it really, it's revealing. It's looking behind the curtain a little bit, right? It's seeing seeing the wizard behind the curtain.
Yeah,
right?
we were talking about this before, and the question that we were sort of discussing is why is this content, or why is this sort of content not out there, and why is sort of the industry holding this back?
Yeah,
and largely. And correct me if you think otherwise, is I don't think a lot of lawyers want homeowners to know this at the end of the day. This, because what we're really framing here is ways that homeowners can approach bad HOAs and try to resolve a dispute without using a lawyer.
Yeah.
Right?
Yeah.
I mean, at the end of the day, that sort of, you can see it. It cuts against the HOA attorney's self-interest in a lot of ways.
Yeah. And I mean, there's a company, let's go company, not we'll get out of the guise of just law firm. The point is to make a few dollars, right?
Right.
So that goes against a lot of law firms. So, and I always, what I always appreciated was the fact that the approach of let's go homeowner first. Let's figure out if there's a way to give them a method to resolve these themselves. And even in consults that happens, I know frequently hey, here's some paths, try this first. If this doesn't work, then come back to us.
Well, yeah, my theory is, the best surgeons don't lead with surgery.
Right.
Right. There are other ways, there's other alternatives. Let's at least empower the homeowner base with that information first and foremost.
Yeah.
Run those plays, see if you can get it resolved without the lawyer.
Right.
If you do, that's a huge win.
Yeah.
And if it doesn't work out, and sometimes it's not going to work, and it's not going to work because the HOA is so awful.
Yeah.
Right. Let's be honest. They're just these horrible people on the board that no matter how reasonable, how strategic the homeowner is, they may not, wave the white flag.
Yeah. They need that extra leverage in order for them to do something.
They need someone to come in over the top. They need to turn on the war machine. And we respect that. But before you turn on the war machine, before you start putting money and investing in a lawyer, this episode is really about other alternative strategies that you can deploy first, and hopefully get some traction.
Yeah.
All right, let's go down this list. We created a beautiful list here. I really like it, like a checklist. All right, so first one: don't get emotional, be clinical.
I love this one,
and this one is interesting because when I read and we consult with hundreds and thousands now of homeowners, right?
Yeah.
And when I read their emails to the board, I applaud them because you can see the emotion. You can see, this is really encapsulating what they live through on an emotional basis. Yeah. And so I applaud that. I say, I get what you're doing here. And I think any rational person would probably do the same.
Yeah.
However, at the end of the day, it doesn't advance nor help you legally.
Yes.
Very rarely does it ever move the needle in the right direction. So really what you have to do is you have to take that emotion out of it.
Yeah.
You have to remove the fact that, this has impacted your life, your family. It's been absolute horrible situation. And you have to articulate things to the board, even though you don't want to. And I get that. It has to come across clinical.
This is really playing the long game here. And when I started looking at this and we started to discuss the topic, I was thinking this is really a long-term play. If you've got a dispute that's brewing, you need to play the long game, because in a lot of situations, what you're doing is you are presenting yourself as the reasonable party.
Correct.
To the extent that you can do that, you've got a lot more leverage saying, I've been extremely reasonable. Here's everything
Since
I
day
got.
one.
Since day one, from the start of my correspondence, I've been extremely reasonable.
Right.
Here.
And when you say long game, what I think that's really getting at is from day one, the correspondence with the HOA from you has always been reasonable.
Yes.
Has always been clinical, matter of fact. You take out the emotion, you take out the name calling, the frustration. And so if, this ever gets in front of a mediator, a judge, or a jury, they read the paper trail as, this homeowner has been very reasonable, very even keeled.
Yeah. And if the board is being unreasonable and, goes name calling and is wild, then it's going to look very good on you in terms of your legal position.
Yes. So first, huge tip, hold back that emotion. I respect it. I understand it, but it doesn't help.
Yeah.
Right?
Yeah.
So that's tip number one.
Restraint.
Yep. Restraint. Tip number two. This is a good one.
Yeah.
Document everything.
Yeah.
And this sometimes is hard because sometimes conversations happen with the board just casually, or they're, simply verbal.
Yeah.
Right. And so I think you always have to be mindful from a homeowner, one, to kind of see, okay, is this heading into a dispute sort of situation?
Yeah.
And if you believe it is, if there's indication that there is, start sending emails, memorialize the conversations.
That's a good point. So even if you have a pleasant conversation with said board member, memorialize it, send an email follow-up. Hey, great talking to you today about points X, Y, and Z. Looking forward to our next conversation or whatever, just to get it out there.
And a pro tip on that, and I love this.
Okay.
And I've seen homeowners do this, and I get, as a lawyer, I nerd out on this, but it says, dear board member Y, Billy, whatever your name is.
Yeah.
This confirms A, B, C, D, and E. Thank you so much. If this is incorrect, though, please let me know in writing.
That's pretty good.
Right. It's a pro move because now you have a really strong piece of evidence. And then if the board ever says, well, I never said that, then the easy pivot on that is, okay, where's the correspondence, which negates what was said here?
Yes.
Because we requested that.
Yes.
So that's powerful.
That's a pro move.
The other thing with document everything too, and I see this, is when you have emails, just start putting it in a file. That way you don't have to go digging.
Yeah.
I mean, it is just organizationally speaking, the better way of doing it,
Yeah.
as opposed to, oh my God, now I have to dig through 7 months worth of emails.
I think in that, and I would assume that you agree with this, is why don't you start your timeline at that point?
Yeah.
Like pull out the Microsoft Word file, put the date, put when you received a violation or whatever it is, when it started, and then the correspondence. I took a picture of the house this day.
Yeah.
Here's the image, and here's the neighbors. Here's the neighbor doing the same exact thing on the same day.
Right.
I verified it with neighbor X. They never received a violation. There's lots of things that you can do to start putting this thing together.
100%. This becomes that document becomes it's worth its weight in gold. It really is. To have it in real time, you're actually it's almost like a journal of, hey, May 8th they came out, and this is what happened. Here are the people who were there.
Yeah. Pull out your phone, notes. Holy cow! Just start a new folder that says HOA dispute.
Bare minimum notes. Pro move Excel spreadsheet.
Yeah.
With references, cross references to documents.
Yeah.
Or you're just somewhere in the middle. But it's really helpful. It's very valuable, especially if this thing goes south.
Yeah, because and correct me if I'm wrong, if it gets to the point where they're calling you, that document alone is probably going to be your best friend.
Oh, it's like Christmas morning when I get that. All right, document everything. And then next, let's see what we have here.
Oh, yeah.
Yeah. So this one's interesting. And this
because it's specific.
What's that?
Because it's specific.
It's specific, and it also sort of ties into the document everything, but we're looking at selective enforcement. And we're really trying to spot that. And how do you do that? Well, let's use an example. Go ahead.
If you don't mind, can we define selective enforcement?
Yes.
It's all this legalese that I've come
Yes.
to know over the course of several years. But let's talk about what selective enforcement is.
Yeah, selective enforcement is really where the board is targeting or sort of punishing one to the exclusion of others.
Right.
And it may be one or maybe a group, but other people are being treated differently within the community.
And there's, let's call, for example, if there is a provision in your CC&Rs that says that you need to have grass and you went desert landscape, or let's call it paint. Paint's a good
Paint's an easy one.
And they painted their house one color and the other, but it was not allowed, a color that was not allowed. And your neighbor down the street did the same color and said, I want to do the same color too. You painted it. You get the fine,
right.
You get the letter, but the other neighbor does not.
Correct. That would be a good example of selective enforcement. The other side of that coin is preferential treatment.
Okay.
Because what you can say on the other side of it is, well, that other person who painted their color, the same color as you did, who's getting away with it, is getting preferential treatment. They're not getting a fine. They're not getting a violation notice.
Yeah, it could be one of the president's next door neighbor that's really good friends with them,
or the president. Those are always great cases.
Oh yeah, yeah. That's the reason they became president, so they could have the
right
their pick.
So not only really spotting selective enforcement, but kind of going back to the documenting it as well. I think that's critical. Put that in your timeline. Get photographs if it's appropriate, but to document the selective enforcement as well is absolutely critical. But you got to be aware of it.
So let's go back to the paint example. Would you recommend just knocking on George's door and say, "Hey, we bust you for this paint ever?" Like, has the HOA ever said anything about the paint color?
I don't think
how do you do that?
Practical.
How do you do that to prove selective enforcement?
Well,
because I mean, my thought is George is just paying the $100 fine every month because he wants that color, so he's willing to put up with it, or whatever the case may be.
Doing it informally is one way.
Okay,
but then there might be formal ways to request the information. Who else has received fines? So that becomes more of a legal way of approaching it. I guess it depends on whether or not the person is a friendly or not.
Now, let me ask you this. Let's use the same example. Are you advocating for somebody to potentially say, "Hey," write a really nice email. "Hey, I got this citation for this color. I have this person at this address down the street has the same color as me. Here's the picture of theirs. Here's the picture of mine. You can see." Would you start there and see what they're...
You absolutely could.
Okay.
Again, that sort of goes to the reasonableness of your approach.
Yeah.
And by framing it that way, by framing a suspicion, you're not alleging, you're not saying, "Hey, this is absolutely happening."
Yeah.
But if you present it in more of here's an olive branch, this appears to be some sort of selective enforcement. Maybe you don't want to use that. Maybe that's too strong of a word.
Yeah.
But you want to get to the bottom of it. You're opening lines of communication. Now, I would say a good HOA would step in, have a conversation, and maybe it's an oversight. Maybe there's something there. But at least you're opening up the conversation.
They might say they got a warning as well.
Correct. Exactly. And so at least you're getting the dialogue started.
Yeah, but I guess that goes back to the first point: is stay clinical, stay calm,
right?
Document,
even though you might be outraged by it, and I would get that.
Yeah.
But start again with that even-keeled approach. Reach out, and everything. If it's memorialized, assume a judge, jury, or mediator is going to read it.
And I think that's a good point. Like in the early stages of this thing, don't go for the throat. Yeah, see if you can again paint it as you are the reasonable one. You're not going to say, pull out the thing, cite case law and all this stuff, like right from the get-go. See if you can be super reasonable with it. Paint the picture that you're the reasonable one in this scenario.
Yeah, it's like playing chess, right? You don't just start with your biggest players right away. Sometimes you do, but that could be treacherous.
Yeah. Okay.
Secure the board first.
Yep.
Secure the center of the board.
Yeah.
So next one is using their documents against them. And really what we're saying here is, CC&Rs, the governing documents, those are the rules of the game.
Yep.
And so by familiarizing yourself with them, by saying, "Hey, you know what? What they are doing violates this provision."
Yeah.
Or under the CC&Rs, this is their responsibility. So that's where you start to not only dig into those documents, but also pull out the relevant sections.
Yes.
That can be very powerful. And it becomes more powerful than you going to the board and saying, "You're in violation of the CC&Rs."
Yeah.
Right. That's kind of blanket and it's kind of, but it's much more powerful to say you're in violation of the CC&Rs, specifically provision 9.3.
Yeah.
Here's what 9.3 says. Please advise as to where I'm mistaken.
Yeah.
Again, a reasonable approach, but now we're using the documents to support the position.
And we've said this on the show so many times. Those CC&Rs become an extremely powerful tool. In fact, many cases that you deal with are because the HOA themselves is in violation of those CC&Rs. Not that you're in violation, that they are in violation. They are not. They are the ones that are in breach.
Yeah, and I think that's a common misconception. It's, homeowners just assume that the CC&Rs are only provisions that apply against the homeowner.
Right.
But it's a standard in which you can hold the association accountable too. Right? It says, hey, these are your responsibilities. These are your obligations under the CC&Rs. Here's what we expect as homeowners from you. And when that conduct falls short or violates those provisions, that's where the homeowner can enforce.
We live in a wonderful world these days too. It's almost easier than ever if a homeowner wants to try to figure it out by way of their CC&Rs with AI tools and things along those lines, just to try to figure out where they have a footing.
Well, the technology has advanced. I mean, even if you OCR, right? If you do Control F, I mean, there's even sort of simpler tech ways of approaching it. I mean, the original way, right? The original way is just to go through and flip through. That works well. Just go through the index. If you have a virtual copy, OCR it, do Control F.
Yeah.
Then if you're advanced and you're comfortable with the technology, maybe AI is appropriate.
Yeah,
but there's a lot of ways to access the document.
Yeah, find out, see if you can work in these ways to try to get to something quickly.
Correct. So no, I think that's so powerful. The next one I want to talk about is check for conflicts with state and federal.
Yes.
And we've talked about this before, but homeowners have to understand that there is a hierarchy of rules and regulations, right? Federal, state, local, and then that's when the contractual obligations kick in, the CC&Rs and the governing documents.
Yes. And we've seen this in California specifically, that in older communities, I mean, you're not even that old. I mean, the communities that are built in the early 2000s have these CC&Rs that were built before these drought tolerant plants and all this other regulation came through. So it moves the bar. So they might be trying to enforce something that is within state law, but it's in your CC&Rs and they still trying to enforce it.
Right, it's in conflict.
And
so just be mindful of that.
But again, if you can prove that, number one, and then if you can, again, be clinical.
Right.
Like I don't just say, hey, so you're aware, this is what the law says.
Well, the drought provisions and that law and that legislation really targeting, how do we mitigate the drought? How do we, protect California, et cetera? You had these rules and regulations that really promoted that sort of landscaping.
Yeah.
And so that's a very easy one, right?
Yeah.
So if you have a homeowner association, and this was very common at that time, saying, hey, you can't have this landscaping, rip it out, put your grass back in. The correspondence would have said, hey, this is what California law says. This is what your violation notice says. California law trumps this violation. This becomes unenforceable. Please advise. Start there. You don't have to be bombastic.
Yes.
Let them be bombastic at you. Let them step into it, and then you can actually sort of use that eventually against them.
Yeah.
Use that as leverage.
Yeah.
So check conflicts with state and federal. I think that's a wonderful just thing to keep in your mind.
Yeah.
The next one is call out their silence, ghosting. And this is so frequent and it drives homeowners crazy, rightfully. And at the end of the day, ghosting actually can become a very powerful tool for the homeowner to show sort of breach of fiduciary, violation of CC&Rs, negligence, if you will. And what I love is when I see a homeowner, I don't love it happened to them, but I love when they treat it this way, where they reach out, maybe they'll put in a phone call to the management company, maybe they'll just send an email and they get ghosted.
Yeah.
And then 2 days later, they'll do the same thing. And then maybe a week later, they'll do the same thing. But then they send sort of this final correspondence, and the correspondence logs all of the ghosting. Dear management company board, here is the communication trail thus far. October 1st, I wrote nothing. Next day, wrote this, nothing. Called, nothing. And it just logs all of the ghosting.
Yeah.
That becomes such a powerful tool. And then it says, at this point, I'm going to have to speak with counsel and move forward accordingly. But it at least sets a record as to why the homeowner went from trying to work with an association to advocacy, to actually hiring a lawyer. And that's a very, very powerful form of documentation.
I think this continues to go back to, remember that you're playing the long game here and you're setting up the idea that you're the reasonable one.
Right.
You continue to, from the first correspondence all the way here, you are being clinical, cunning, strategic, and you're trying to do it amicably. You're trying to do it with some level of level-headedness.
Right. And even though technically speaking, you might not be level-headed rightfully, because it's such a nightmare. It's so horrible. This board is so bad.
Yeah.
But at the end of the day, it's what is written, what is memorialized. And that's how you're going to come across it, in a third party's eyes.
Yeah. We've discussed it before. In terms of ghosting, talk about a little bit about IDR in that sense as well.
So IDR becomes a very interesting tool.
And can you define it for the people that don't know? I mean, we talk about it so often that it becomes like, oh, we're talking about this again. But I think it's important to.
Well, it comes up because when it works, it's wonderful. It exists in California. Informal Dispute Resolution under Davis-Stirling Act. And really the spirit behind IDR is to allow homeowners and HOAs to come together and really discuss their issues. And that's really exists before lawyers get involved, at least in theory, it's supposed to. And what it does is it empowers the homeowner to send a notice or a message to either a management company or the HOA or both demanding IDR. And, typically it's, dear HOA, I hereby demand informal dispute resolution under the Davis-Stirling Act. At that meeting, I would like to discuss the following. And then you sort of lay out that dispute. It doesn't have to be a novel, but you say, hey, this is the problem that we're facing. Please respond back in writing and confirm times and dates that you can meet. I'd like to meet ASAP.
Yeah.
And good HOAs respond and they say, we'd love to meet with you. And often these work where there's some sort of communication breakdown.
Yeah.
For some reason, the HOA just never got the information. And that could be because of just a horrible management company, which is a whole different issue. That was another podcast that we did.
Yeah.
But IDRs are great because really the homeowner typically doesn't have a lawyer.
Yeah.
And if they can resolve it one-on-one with the association without a lawyer, without paying for a lawyer, that becomes a huge win. Now, there are other times where we consult with homeowners and we look at the paper trail. And the homeowner is very reasonable, has explained everything in excruciating detail, and it's the association that's just bombastic. At that point, you got to question whether or not it's worth your time, energy to be subjected to more harassment, discrimination, stonewalling, whatever you want to call it. Because IDRs can also go south very quickly, especially if you have a bad board.
Yeah.
You don't necessarily want to spend 3 hours with the tyrant.
Sure.
At the pool house. Right. So you got to use it strategically and use it surgically in some ways, but it can be very effective. And when it works, it's wonderful.
Even so, you go through the IDR process, and let's just say they do respond. They set up a time. You go to it. It's still, you got to keep your head level.
Absolutely.
Like if it's not going anywhere, and then document it. Like I would say, afterward, you're documenting everything afterward. And would you even send a response, say, hey, this is what I understand from our.
Well, I think there's two things, or maybe three things. One, before you show up, be prepared. If you know that the board is going to be there, maybe you have two binders. One with you have all the evidence and you're turning it over to them, and you guys can go through it together, right?
Yeah.
So you're not, so I think logistically it's a bit smoother.
Yeah.
Two, if it's not working, you show up and it's the tyrant or it's the meddler type or whomever it is, and it just becomes very quickly very unproductive. It becomes, they're shouting at you, toxic, maybe that's a good word. Just end it. Thank you for your time. We're done. And just leave. You don't have to subject yourself to that, right?
Yeah.
But then afterwards, it may not be a bad idea to send an email. Dear HOA, I'm sorry that the IDR did not prove effective. Here is my observations of what happened. I would like to create a record.
Yeah.
Not a bad idea.
Yeah. It also puts you in that position that you're posturing like, oh, you're looking to take the next step, which is possibly legal.
You're creating a paper trail.
Yeah.
And that's important,
Yeah.
especially if that IDR fails miserably, and especially if they show up and it is just, again, if it's bombastic, if they're, if it becomes sort of the situation where they're screaming at you, it becomes hostile, toxic, whatever it is. Again, don't subject yourself to that, but that is very inconsistent with what Davis-Stirling had in mind when they came out with the concept of IDR.
Yeah.
In theory, it should be a very solution-focused meeting. And if it's not that, I would terminate it. Don't waste your time.
I think that's important. The point of this, the whole point that is in there is to try to get this resolved without legal intervention.
Correct. And again, that's why I think it's a wonderful tool when it works, but when it doesn't, it can fail miserably.
Yeah.
So I think the last point, and it kind of dovetails nicely, is when to lawyer up.
Mm-hmm.
And so
I think, can we say one more thing about that? And we've talked before we jump right into that.
Yeah.
We've talked a little bit about elevating your vocabulary. I think it's worth noting that you're keeping it cool, you're keeping it somewhat casual, but to the extent that you can prove that you're very well read on the topic, and you can start pulling out certain nomenclature and say, and pulling out like statutes.
Yeah.
That might show, again, being from a strategic standpoint, that you're serious about the matter.
Or you're educated and you're empowered.
Yeah.
And I think that's important.
Yeah.
You don't often get much traction, or I don't see a lot of success when you have a homeowner who's just yelling, saying, you guys are horrible humans. This is a dumpster fire. And it's all valid. Like I understand why. Yeah. But let's be more tactical.
Yeah.
Let's say, instead of saying you guys are a dumpster fire, we say this is likely negligence, or this is a violation of the CC&Rs, more specifically this provision.
Yeah.
That is a very tactical approach that actually moves the needle.
Yeah.
More so than getting out all that venom.
Yeah. 100%.
And so, I think the lexicon, if you can elevate it, and if you can put in those words and leverage them, it becomes very effective.
It just shows that you mean business.
Right.
And it shows, they're educated, and this can escalate quickly.
Correct.
We probably shouldn't mess with this person.
Correct. And, they're going to think, well, how well is this going to read in front of a jury or a judge or a mediator?
Or at least the lawyer on the other side, to the extent it's brought to their attention. That's what they're thinking. The opposition's legal counsel will definitely be thinking
so let's stack the deck in your favor.
Yeah.
And that's what we want to do.
Okay. Sorry to get off.
No, that was
the,
good.
the rails.
I appreciate that.
When to lawyer up?
So often it's very clear when to lawyer up. When you see one, I think when they're ghosting you.
Yeah.
If they're just ignoring you, this is a serious issue. It's impacting your life, your economics, the property value, your quality of life. Talk to a lawyer. And when I say lawyer up, I think the appropriate step initially is always a consultation.
Yeah.
Meet with a lawyer, have a lawyer objectively look at what's going on. So if you see that the HOA is simply ghosting you, you attempted IDR and it was absolute horrific event, right? It got nowhere.
Yeah.
Not because of you, but because of them.
Yeah.
Where there's a situation where the association has all the information, they have the information, and they're still stonewalling you.
Yeah.
Or they're clearly in violation of the CC&Rs, and you've brought it to their attention over and over again, and they're doing nothing. These are signs that you're probably dealing with a really bad HOA, and you probably do need some form of advocacy.
Yeah.
To get this thing moving.
I want to kind of put emphasize advocacy, because especially for the homeowner, God bless them if they've never been involved in a lawsuit before. It's not a pleasant experience.
Right.
But many people, you're dealing with this every day. But the average homeowner, it's possible that this could be their first rodeo, right? I think there's a temptation to call whatever lawyer right?
Right.
Like, Aunt Jilly is as a real estate lawyer or a transactional lawyer. What is a lawyer? Period. Insert whatever type of law that they deal with, and to go with them and just get some, buddy legal counsel. Right. The one thing that I will say as an outsider, which kind of blew me away a little bit, was that if this is done incorrect, this is a very nuanced part of the law. And the one thing from being in the show that I realized that if you do the steps wrong, you might not be able to recover your attorney's fees if you don't follow the proper steps and procedures.
Well, among other things.
Yeah.
And we've seen that historically, real estate attorneys will step into the space and really not understand the import of the governing documents, the fiduciary duties that are involved, the Davis-Stirling Act, the case law that kind of interprets all of this. And it can be very complex and overwhelming if you haven't lived and breathed it.
Yeah.
Now, we've been at it for 17 years, so we understand it very well.
Yeah.
But you have to be very careful with the advocacy within this type of dispute. Because I promise you, the association attorneys, they understand the space very well, right? So if you're going to go to war, you have to make sure that your advocate can fight toe to toe.
Yeah, and then so many stories I've heard on just being the side of the gamesmanship that sometimes the opposition will play if they can smell blood.
Oh, very true. Yeah. So even if, let's say, you have the real estate attorney who's done their homework, and there are real estate attorneys who can do that, who can educate themselves and sort of get up to speed. But they have to know sort of the industry and the gamesmanship that is often deployed by the association counsel.
Yeah.
Right. The tactics that they use, the delay tactics, the roundabout, the negotiations that really don't go anywhere.
Yeah.
That's very common. So you have to sort of understand not only the law and how to operate within that and how dynamic that is, but you also have to understand how do the association attorneys approach these type of disputes.
Yeah, because they might just try to squeeze you and run up attorney's fees.
Oh, there's so many tactics.
So you might just say, forget it.
Well, here's a common one I see quite frequently. When homeowners eventually come to us, they say, hey, I've had this attorney for 8 months. And the attorney has been negotiating with the other side. And it looks like we were getting a lot of traction. But, last week, the association attorney told us to go kick rocks. But I've spent a fortune in negotiations.
Yeah.
Yeah, that's a common trap. That is the rabbit hole. That's what, association attorneys love it when a newbie comes to the space and they act very friendly. They say, oh, this is great, very interesting. Send me some case law. Let me read this. Let's do a site inspection. Let me go to the board. Oh, the board can't meet today. They're going to meet in 2 weeks. Can you hold it for 2 weeks? But then 2 weeks comes and then there's another delay. It's huge gamesmanship.
Yeah.
You have to understand the space.
Yeah.
So how do you keep aggressive in the space? How do you keep them on their heels? How do you keep fire on them? That's part of the strategy.
Yeah.
So choosing the right advocate is important. But again, I think it always comes with a good consultation and someone who can look at it and say, hey, here are your options.
Yeah.
There's typically more than one option when it comes to going after an association or a bad HOA. And then also analyzing the sort of the economic side of the scale too.
Yeah.
Because you got to flesh out the legal side.
Yes.
But what do the economics look like as well? And both sides have to make sense at the end of the day.
Yeah. And I'm sure there's lots of attorneys that are just, they don't mind if it goes long.
Right. So let's find out, sort of what makes the most legal and economic sense in prosecuting your case against a bad HOA.
Let's talk a little. Let's button this this section of when to lawyer up with some of the other things that come up that might signal to when to lawyer up. The first one we said was if your demand was being ignored, if you were ghosted. What are some of the other areas that is a good signal to lawyer up?
Yeah, so I think when you start to get letters from lawyers, that's a good sign. When they've already lawyered up, maybe at that point. When there's liens being filed, God forbid foreclosures are coming into play, your actual property is being threatened.
Yeah.
When you understand that the makeup of the board is filled with tyrants, meddlers, or board members who fundamentally are unreasonable.
Yeah.
When you've heard historically that the board may be weaponizing their lawyers. These are all signs that, it's probably time to at least at minimum talk to a lawyer.
Yeah.
I think that's probably at least some initial red flags that you should be mindful of.
And I think what if they just threaten a lien or foreclosure? I mean, I feel like that's
well, typically that comes by way too of a lawyer or a lawyer's letter.
Yeah.
So these are all strong indications that it's probably time to pick up the phone or at least get on the internet and do your research.
Okay, well, let's go over. This was an interesting. As you know, we try to pull out some real world stories, and I think it's a fun way of just trying to get in the head of an attorney, right? I'm gonna tell you, I found it on Reddit, and I'll just read it to you. And I just found this. This actually took place. It just came up on Reddit, but the story actually took place in early 2018. So I just want to read it to you because I found it to be pretty incredible. In early 2018. The HOA adopted a rule requiring residents to keep their garage doors open from 8 a.m. to 4 p.m. Monday through Friday. Non-compliance could bring a $200 fine. The HOA explained that the rule was meant to prevent unauthorized occupancies of garages, people secretly living in them. Residents objected, citing privacy, security, and basic common sense. After backlash and media coverage, the HOA later rescinded or suspended the rule, stating that they would work with homeowners to craft a more reasonable policy, which is wild. There are so many things in that story that how can they even, I'm going to ask you, how can they even pass a rule with that?
Well, the question is, you can maybe pass any rule, but the question is it enforceable? Right. Is it actually going to hold? Is it going to carry weight? Are the courts going to allow for it? And something like that is such broad overreach of a board. It has so many problems with it, right? From a privacy perspective, from a safety perspective, and simple competence, right? It's one of those things that is so incompetent.
Yeah.
That it's beyond the pale.
But then also you are, if you kind of wind this back, I'm assuming it's one, at most two people that they suspect they have this problem with.
And maybe so. Well,
but to punish the entire neighborhood seems wild.
Which goes to incompetence. This to me seems like just a really bad idea that came up in a session, and two other incompetent people were like, yeah, that's a good idea.
But can you imagine this affects them? They probably don't care because they're at home all day long.
Maybe so. But there was no adult in that room to say how horrific of an idea it was. And typically that's, hopefully the job of the HOA attorney to say, board, thank you for this idea. This is a horrible idea. Here's why: privacy, safety, etc.
Yeah.
We can't do it. Come up with another solution. Because the concern, okay, fine, valid. The problem, valid. But their way to cure that is outlandish. It's beyond the pale, right? So, and you see this with HOAs all the time. They have somewhat of a valid problem, right? Maybe it's speeding, maybe it's safety. But the way they go about it, that's the problem. It's either negligence, it violates the CC&Rs, it violates state law, or it just violates more fundamental rights, that of privacy, right? Or it opens up some sort of big safety concern. So as I see this is a perfect example of just pure incompetence. The problem is legit. I get it.
Yeah.
But your approach is just so outside of this realm of reason.
Well, and there's I mean, the CC&Rs bylaws, I mean, there's rules on passing rules, right? That you can only imagine if they're willing to go to this length, did they even do the correct way?
The question is procedurally.
Yes.
Yeah, procedurally, maybe it's wrong.
Yeah.
And you could probably attack it on that front as well. But there's so many other ways to attack something like that as well.
Okay, just throwing it out there. In something as wild and insane as this, do you think it's in the homeowner's best interest to try to circumvent the board and go directly to the representative, as in their attorney? I mean,
typically not. No, that's not The problem with that is the attorney for the association would likely have some issues talking directly to a homeowner.
Okay.
And there's some rules of professional conduct issues that could arise, and it can get a little bit muddied. The better way of approaching it is just, it would be through maybe open session.
Yeah.
It could be through IDR.
Yeah.
Right, like we discussed before. A more aggressive way would be ADR, which would be alternative dispute resolution.
Yeah.
And once you send an ADR demand, it would likely go to that attorney.
Yeah.
Right, as opposed to calling that attorney at the law office.
Yeah, my thought was there needs to be an adult in the room kind of a situation.
And there's ways to sort of trigger that and get it on that attorney's radar without the direct call to the attorney.
I understand.
And again, I say that not necessarily because that's a bad strategy, or I just think that the attorney might raise some issues under the rules of professional conduct.
Okay.
Talking directly to a homeowner, that homeowner might be represented by counsel. These are the questions that will go through that attorney's mind. So there's just better ways to, I think, get this in front of that association attorney as opposed to a direct call to that attorney's office.
Yeah. Interesting. What I found particularly amusing about this case was the responses by some homeowners. They said, okay, the garage needs to be opened from this time to this time. So they only open it a couple of inches.
Okay.
Like, I just found that to be humorous.
Because there's an ambiguity with the...
exactly. They didn't say it needs to be all the way open. It just says it needs to be open. So they would just pop their garage doors open just...
that's a good workaround. That's fair. Just enough to let snakes and rodents in?
Yeah. In that situation, though, we've talked a little bit about, hey, whatever it is, pay the fine, and then get the adult in the room, get the attorney. And something is $200 for each violation is extreme and is no longer valid here in California. But when it was $200 a day, you're saying, would you advocate for these people pay the fines and then get counsel as soon as possible?
Yeah, I suppose there's a number of ways to cut something like this. I mean, one way, as soon as this happens, I mean, you could get IDR on the books. You could, force their hand at some sort of open meeting. You see what I'm saying? I mean, you can sort of rally the troops, if you will, and sort of act and mobilize immediately. Yeah. So there's ways of doing that. It would be through IDR. Again, you go ADR route. Yeah. There's different ways to cut it. And I'm sure that there was a lot of homeowners very upset about this.
I'm sure.
So it wouldn't be that hard to get a town hall going, right? Or get everyone to show up at a meeting. Yeah. So no, this one ultimately I think would have been resolved pretty easily. And this is maybe even a good example of one where you wouldn't need a lawyer.
Yeah, because you have enough. You
have so much ammunition. You have so much outrage. I would imagine by way of this obscene rule or absurd rule that lawyer involvement may not even be necessary. Yeah. So good one though. I did not hear about this one. Yeah,
that's a fun one. Let's just do a quick recap because I'll take it from the stuff that I feel like is most important. The thesis of the thing is number one, stay clinical. Like right from the onset.
Yep, clinical.
Document everything like right from the get-go.
Make that record.
Yeah. Emails, even if you talk to someone informally, memorialize it, send an email, recap it. Say that if you have if my understanding is different, please let me know what that difference is.
In writing. In writing. Please respond in writing.
Yes.
If I'm mistaken.
Yes. I think those are request IDR, informal dispute resolution could be huge for them.
Be mindful of IDR. Be mindful of state, federal, sort of the chain of how these laws work, right? The authority. Yeah. And then also really understand that citing provisions within the CC&Rs, actually using those documents to enforce your position carries so much weight.
Yeah. Review those CC&Rs. It's in this day and age, there's no excuse. It's so easy to do today. Get that, pull those things open, figure out what they're violating, and then be clinical, respond back to them. Yeah. There's a lot of good tips in here. So,
well, this was a fun one, Marty.
It was.
And so thank you guys for watching. It's always a pleasure. Again, if you like the show, like it. If you subscribe, that's wonderful. We appreciate all the subscribers to the show to date. Leave comments. We read those comments.
We do.
And
there's a lot of fun things there's a lot of fun things coming. We've
Yeah.
got some big plans coming. So
Yeah,
I'm
I think
excited.
actually next episode we might be rolling out
Yeah.
some of those, some of the things that we have up our sleeve.
You know what I appreciate is that we continue to want to push changes and advocacy for homeowners. We want changes in the HOA space and to really help homeowners at the end of the day. And I think that there's a long-term vision here that we're still, and there's a lot of cool things in the pipeline I'm really excited about, and I'm excited that we're going to be able to share those relatively soon.
How do we eradicate bad HOAs? I mean, at the end of the day,
that's the mission.
It's empowerment, it's reform, it's education, it's advocacy, it's all of these things.
Yeah.
And the goal is to eradicate.
Yeah.
Big goals.
Yeah.
So,
indeed.
All right. Thank you, Marty. And thank you guys for watching.